Welcome to eDiscovery Leaders Live, where I get a chance to chat with luminaries in eDiscovery and related areas. This broadcast is sponsored by Reveal-Brainspace, the industry's leading AI eDiscovery platform. Don't forget to subscribe to watch me, George Socha, weekly with leaders in eDiscovery. Thank you for tuning in. Welcome to the 121st episode of eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. I am broadcasting this week from Chicago, a stone's throw from the L, so I'll try to mute my microphone as the trains go by. I might not always be successful. I am George Socha, Senior Vice President of Brand Awareness at Reveal. Friday mornings at 11 a.m. Eastern, I host an episode of eDiscovery Leaders Live where I get the chance to chat with luminaries in eDiscovery and related areas. Past episodes are available on the Reveal website. Go to revealdata.com, select resources, then select eDiscovery Leaders Live. Our guest this week is Adam Wehler. Adam is the Director of Practice Support at the law firm of Robinson Bradshaw and Hinson. He is a resource for the firm's lawyers on eDiscovery related issues ranging from all the way from collection to destruction of documents. He is also actively involved in the information governance support within the firm. Adam focuses on client discovery, whether local or worldwide, and strives to make sure that everyone understands all the nuances that eDiscovery can hold a major challenge there. Adam, welcome.
Thank you so much for having me today. I'm very excited to talk with you.
And we're glad to have you here. Now, you have told me in our discussions that your firm does things a little bit differently, and I'd like to start with that, not about the ways you are similar, but the ways you differ from so many other firms out there.
Yeah, I think our firm is really pushing us to be more efficient. Robinson Bradshaw, really focuses on picking the right lawyers for the task at hand. And that could involve transactional lawyers and litigators working together, even within the eDiscovery space. And so one of the things that has really pushed our group to do is not only focus on the data life cycle when data comes in and leaves the firm, but focusing on what different type of technology is out there beyond your typical eDiscovery technology. And so we've really had to get our hands dirty in due diligence technology such as Kira and the like, and have had to, I think our eyes really opened to apply a lot of different process around that technology and really see how different AI is depending on the legal arena. And I think that's really made us better in the eDiscovery space.
You, as I recall, though, you've got another difference that I'd like to have you bring up, because when you mentioned it to me, I went, what, really? How does that work? And it's about billing requirements.
Yes. Our firm is focused on efficiency, and there are no billing requirements, that or standards that I've experienced that were standard at past firms. And again, the point is to get the work done in the best amount of time for the client. We don't have a need to keep associates or partners busy. We get the work done efficiently, and that's what really brings us to apply the right technology. And I think, we look at legal technology like you would look at clubs in a bag of golf, golf bag. You're not gonna know what you're gonna hit before you get to your ball. You have to analyze everything around it, where the pin is, how far you're away, what the wind is, before you pull the club out. And so, you may want to use something like HiQ or Kira or eBrevia or Reveal or Relativity differently depending on the technology, the problem issued by the different people.
So how does that then play out in practice?
So, for example, we sit down and have a lot of collaboration with our attorneys. And I think one of the greatest things that we have done here is basically beat our drum that if you have a problem, we'll solve it. And we will know all of the technology that we can grab to solve it. And one of the greatest things that I've experienced here is our startup group. We have access to talk with them and know the different companies that they're helping. Infinia ML is a great example. They're doing AI in a different way where you can train it to pull data out of documents randomly in a great way. I mean, again, it's not patterned to e-discovery or corporate or transactional or anything. I think that's one of the amazing things of how it works in practice is we have access to the top partners. We are constantly communicating with people in trust and estates, in real estate, in obviously all the litigators. So I think that's one of the things that's really, really helpful.
I get the impression more generally, so this is not about your firm, but more generally, that often folks in the litigation support or e-discovery or practice support group, to a certain extent, live siloed and in isolation. They serve a small number of the firm's lawyers, and most of the lawyers in the firm don't make use of them. It's sounding to me as if you are in a very different situation from that.
Yes. A typical day in the life of our group can run from talking to our general counsel about information governance to talking with a transactional lawyer about a big due diligence to dealing with our trust and estates people about an estate that they need to review data through. And then we are talking to a client at the end of the day about the EDRM and e-discovery process. The great thing here, I think, is where I come up with what I like to call my theory of everything. And I think that siloed nature, while great, you are in a law firm and you need to be specialized. You need to know how your technology works. But I think I had the seeds planted about, looking at technology that may apply to a different law practice and seeing how you can apply that technology to a different law practice. I mean, we are trying to remove labels that, hey, Reveal may not be just for e-discovery. It could be a great due diligence tool, and this is how. And I think that's where, again, the theory of everything. Let's combine and not silo technology to that's a litigation tool, that's a transactional tool. Let's make it that's a legal technology tool. And now you start removing proliferation of technology and kind of getting overwhelmed by we're using 30 different tools and so on and so forth. So yeah, that's really what's exciting about our firm.
Give me some numbers to give context. It doesn't sound to me when you talk about we that you're talking about just yourself. So there's got to be more than just you, I hope. And then how many of you are there? How many people are you supporting?
So right now, the law firm has around just over 170 attorneys. We are a mid-sized law firm in the Carolinas. We have clients all over the United States and outside. Our department specifically has 8 other people in it who range, I like to call it the 3 pillars of practice support, ranges from what I like to call knowledge services. They handle information governance and knowledge management. We have legal technology consulting. As you can see, no specific practice area where they handle e-discovery, transactional technology consulting, and then I think one of the biggest wins is we have a legal process coordinator as well. And it kind of goes back to my theory of people, process, technology in that order. You have to really pay attention to the people you are talking with, what their issues are. You need to surround solving that issue with a process, and then that can allow you the ability to pick the best piece of technology. Our ragtag group of 9 does a really good job of applying that on a daily basis, and making sure that we are able to know everything about data at the beginning, the whole way to the destruction of that data. Because we may be able to, a la chessboard, predict where the moves are going to be made so that we can then add even more efficiency. Because if you are tracking your data when it comes in, you might be able to make hypotheses about where it's going to go. And if you are somewhere in the ballpark, you can then save your client time and money, and that's the goal.
You are clearly working regularly and closely with the lawyers in your firm. What sort of contacts do you have with the law firm's clients?
We are typically in contact with the clients on a regular basis. We are talking about various amounts of, whether it's e-discovery, how to get the data, data mapping. Your listeners will be very familiar with all of that. But we are also engaging with our clients to come up with various solutions to their problems as well, using and leveraging our technology. We engaged with one of our clients to find a unique way to go through their COVID vaccination exception process, and how to review that data and how to approve it or deny it. We have engaged with clients to, figure out the best way to organize their important company data. Where, if it's for example, if it's a multi-state client, all of the origination documents and the like. And so we are able to, again, at the base, solve issues with process and technology. And I think that's one of the things that I'm the most proud of. And again, I hate to bring people on your podcast to the transactional side, but
that's perfectly okay, by the way. Go there.
I'm super proud about our legal process coordinator and our firm through our Climb project, which is a pro bono project that reaches out to businesses to help them that you may not be able to afford a law firm to be able to help contract creation and fund creation, all of this other stuff on the transactional side. And it is something that we are used to helping out. How can we better work with collaboration and the like? And so again, it's just a program that I'm really proud about, and it goes to the collaboration of our firm. I think it's being able to have that conversation that our lawyers are saying, hey, I don't understand technology, and the partners at our firm, I really feel there might be a better way to do this. Let me ask the question just to see.
You mentioned earlier a couple different times the use of AI in ways that suggest that you're using a variety of types of AI in a variety of ways. to get there, I assume that also means looking at a much larger array of capabilities, doing a fair amount of testing. What does that look like in your organization?
So, when I started, way back when I went to college for astronomy and astrophysics, and that involved a lot of calculus, that involved a lot of math. And at the end of the day, when I look at AI, when I look at all of the different types out there, it does not seem as daunting, because I know that, again, it's just algorithms. And that's what we're basic with. And again, something I tell attorneys, you can't be scared of AI because you use it on a daily basis. You look at Amazon, you look at all of the things that you use on a daily basis. So when we look at that AI, we want to try and push it to do different things. AI is very different depending on your transactional side versus your litigation side. And we look at a tool such as Kira, and we are saying, okay, what we want to do in this due diligence process is pull out all of the clauses that might be problematic. Throw in 1,000 contracts, we're going to pull out all of the ones that have a specific termination. And it's going to pull out the clause, the part of the document that it has, which is markedly different from when you're dealing with AI on the litigation side. You're looking at the whole document and conceptually what's similar. And so we're looking at Kira and say, well, where else can we do that? Let's test it. And we were testing it for crazy things like transcripts. Like, okay, can I have a bunch of litigation transcripts and pull out certain parts of those transcripts? Again, if you have a bunch of depositions and you want to pull out damages or certain things from all of those different transcripts, why can't I train it for that? Again, it's just algorithms. It should be able to be trained. And I think this is one of the things, again, go back to my theory of everything, that I'm excited about Reveal, is you all bring in your tool the idea to pull out portions of the document. And so theoretically, I could train your tool to be a great due diligence tool, and because I can pull out those parts of the document that contracts need.
And so there you're talking about the notion of high precision classification. So rather than me defining what that is, let's hear what your definition of high precision classification is. I'm going to put you on the spot here.
Yeah. I mean, again, my definition would be basically coming from a transactional perspective, because I need to know that those two sentences are going to be conceptually similar across multiple documents. And so if I'm looking at a sunset clause, I know that I'm going to pull back a bunch of documents with a conceptually similar sunset clause. And that's what I'm going to get. And, taking it a step further, I'm going to be able to pull it out in an Excel spreadsheet and analyze it for the impact that it's going to have on the various due diligence process. I think from a litigation side, it's just amazing the places that it could go. Because before you could, look for a conceptually similar paragraph, but you got a whole document back. Now you can get pieces of that, and that's huge.
So, I at least can see the value of that on the litigation side. I don't think that's that hard to see. On the corporate side, you talked about using it when dealing with contracts. What other uses can you envision on the corporate side for a high precision classification?
I really think that we can go and look at it from a knowledge management perspective as well. That's something that we are dabbling in, and one of the things that I want our attorneys to know is that we want them to not have to work harder. Again, our firm is all about providing efficiency, and so if you're going to write a great contract, and you're going to say that, only I know that this certain clause from Britain is applicable in this situation, we are going to be able to go out and identify that clause across multiple contracts and be able to save that clause and, provide it in a knowledge management perspective. I think from our perspective, that's invaluable, because now you don't have to remember which contract you went through. You can have a whole system dedicated to the important things, and automatically analyze contracts to see if I can see conceptually similar, I can see the opposite. And now I can take advantage of maybe a bad contract or something in a due diligence process.
So I'm going to return to something you mentioned earlier, but put it in this context and see if you can go in a little more in depth. These sound like innovative, creative uses. They sound like they can deliver potentially great value. However, they're only going to deliver value if they actually get used. How do you work with your firm's lawyers, paralegals, and whoever else is necessary to take these things from concept to execution and successful execution?
I think you always start, it goes back to the things that I learned, way in the beginning. I had great teachers like Bennett Borden, and others like him, that you start with simple wins, and you gain the trust through those simple wins, and those simple wins allow you to take bigger risks, and say that, hey, I'm going to take this data, and we're going to basically, I have stated a lot of dual track. We're going to do it this way that makes sense for you, but I'm also going to do it the way that I feel is going to get the best product. And I'm going to show you both, and we're going to have you decide what you see. And when we've been able to do that, when we've been able to, take relativity or reveal and put it in front of a due diligence lawyer and say, hey, yes, you have these tools over here to review your contracts, but let's put them over here. The eyes have been open. Where has this tool been? For a long time. And it's one of those things that, again, this firm is built off of thinking differently at the lawyer level. Again, from the beginning, staffing, transactional lawyers and litigators for a specific client, whether it is transactional or litigation. And I think that's the great thing that then also filters down to our group, that allows us to, hey, we've done this. Let us experiment and let us show you that we can do this. And I think a lot of the lawyers have the patience for that, because we know that we can get it done in an efficient manner. And it, again, goes back to all of those little wins that we have built up over the 7.5 almost years that I've been here at Robinson Bradshaw.
Taking that then to the next level, with the innovative approaches, creative ideas, once you get buy-in from your firm's lawyers, what's the process look like to convince clients that this is, whatever this may be, that this is something that it's worth them agreeing to have you do?
One of the great things that I really appreciate about this firm is that when clients engage Robinson Bradshaw, the trust level is incredibly high. And I think one of the things that allows is our lawyers have engaged me and people in our group to then partner with them on the call to the client to describe. There's less of a telephone nature, whereby I tell the partner, this is what we're going to try. Then the partner goes to the client and tries to regurgitate that. There's a lot more of a, wow, that seems really great. I want you to be a part of this call. And I think, again, collaboration. I've said that term, and my team gets tired of me beating that term to death, but I think that's one of the greatest things, is putting the person on the telephone that knows how to take a complex subject and distill it down to something simple. Einstein did that best. Again, going back to my astronomy and astrophysics days. But I think that's the greatest power that our firm has, is that we are there to describe what we're going to do with the client. And so that makes acceptance of what we're going to do pretty easy.
The approach you're describing reinforces, at least for me, what I heard you say earlier about the high degree of trust within the firm, because it suggests that that trust extends to a willingness to take you or one of your team members, put you directly in front of what could be a very important client for the firm, and let you take charge with the discussion and direction, something that isn't always the case.
Yeah, and I have been lucky to have various people across my career have that trust, and it really, I mean, whether it was Gibson, Dunn and Crutcher and Bennett, or Steptoe and Johnson and various attorneys there, it's something that I have been used to, and something that was a very easy fit coming here, because we are here to support our attorneys and make them, again, one of the things that I try and tell them, you are amazing legal scholars. You guys have studied hard. You know the topics that you are practicing law on. I don't want you to have to also study the technology that goes along with it. And it's great if you know it and you can, eloquently speak about it, but I want you to shine as a lawyer. Let me shine up on the nexus between legal and technology, because that's what I've studied for almost 18 years. And that's what we're here to do.
In the discussions we had in preparation for this, there were a couple of additional things you brought up. And before I close, I'd like to touch on both of those. First is that the way you go about charging clients for the use of all of this, because that too is different from typical. Describe.
Yeah, I think the point that our firm really makes is that our technology is here to help, not here to really make the firm money. We are here to, bill through. We try and make it a point to make the billing simple. We are trying to bill on just size, for example, or just a per page on the transactional side, and nothing more. No user fees, no this, no that. We want simple, we want clean, we want efficient. And we are going to try and be able to leverage the best technology for the clients and not make them bear the brunt of that technology as much as we can.
The last thing then I want to cover or touch on is what you described to me as your second biggest win. I'm assuming you remember what that is. Okay. Tracking data and what you're allowed to do.
Thank you very much. Yeah, my first biggest win with legal process, but yes, I feel that we can only be as good as knowing where our data is. And tracking data from inception to close is something that I feel allows our department to be uniquely powerful and able to move. We have set up, kind of a centralized docketing, a centralized information governance, whereby we know when cases start and matters start and data comes in. And then we have an amazing trial presentation department and an amazing retention schedule whereby we know when data cases should be closed and cases should end. And so if we know where all of this data goes and how everything moves, then we can leverage it in a very efficient way. Again, to my knowledge, there are only maybe 5 places currently, and I think this is one of the most exciting things, where people can place data on our network. And the more you leverage that, again, simplicity, cleanliness, we want to make sure that lawyers know where to go, and how to move data around. Again, props to our IT department for helping us believe in our vision. But that's, I think, one of the, I agree, my second biggest win, because again, you can only be as good as knowing where your data is.
Well, that sounds like a great way to close. Thanks, Adam. Adam Wehler is the Director of Practice Support at the law firm of Robinson Bradshaw and Hinson. I am George Socha. This has been eDiscovery Leaders Live, hosted by ACEDS and sponsored by Reveal. And Adam, again, thank you very much.
No, thank you. The pleasure was all mine.